Imagine your state government just blatantly violates your constitutional rights.
Oh, wow. Okay.
Yeah, we are talking a totally clear-cut, undeniable violation. And as a result, they owe you millions of dollars in damages.
Right.
So you have the evidence, you have federal law completely on your side, and you take them to federal court. You stand before the judge, lay out this airtight case, and the judge just looks down at you and says, "You're absolutely right, but I can't do anything about it. Case dismissed."
It sounds like a total breakdown of the justice system.
Right.
But it's actually one of the oldest structural features of American government. You just hit a wall that was built into the system long before you were even born.
Well, welcome to the deep dive. Today, we are cracking open a stack of notes and scripts from two incredibly dense sources.
Very dense.
Yeah, the MBE Constitutional Law Prep Masterclass and the Law Student's Guide to MBE Mastery. Our mission today is to decode what might just be the most complex, trap-filled area of constitutional law, which is state sovereign immunity.
It is a massive trap.
It really is.
Yeah.
And, whether you are a law student staring down the barrel of the bar exam, or you're just an insanely curious mind trying to understand how the government seemingly gets away with things that you never could, this deep dive is your shortcut to understanding this ultimate legal shield.
Definitely.
We're going to break down, who gets to hide behind it, the extremely narrow hidden doors to get past it, and the strict rules of engagement when citizens take on the state.
Yeah, and to understand how to bypass the shield, you really have to understand why it exists in the first place and exactly who it covers.
Right.
So the baseline rule we are dealing with, which comes directly from the 11th Amendment and, over a century of Supreme Court doctrine, is that a state is generally immune from private lawsuits in federal court.
Just completely immune.
Just immune.
Yeah.
And that remains true even if the person suing is a citizen of that very same state.
Wow. Okay.
Yeah, the state just cannot be dragged into federal court by a private individual without its consent, period.
That is wild. But the sources actually provide a really brilliant framework to cut through all the noise of these complex cases. They call it the 4 questions.
The 4 questions, yeah.
Right. So whenever you're looking at a scenario where someone is suing the government, you basically just ask, 1, who is being sued? 2, by whom? 3, for what relief? And 4, under what law?
Answering those 4 questions, in order, it takes a problem that feels incredibly abstract and turns it into this mechanical, reliable checklist.
I love the checklist.
Right. And question 1 is always the gatekeeper. Who exactly counts as the state?
Because the shield only protects the sovereign, right?
Exactly. The shield of sovereign immunity only protects the sovereign. So the state itself gets the shield, and state agencies, which the law refers to as arms of the state, they also get the shield.
Okay, so like the DMV or something?
Yeah, the Department of Motor Vehicles, the State Department of Revenue, the state university system, they're all covered.
Okay, but this is where the trap comes in. If you're sitting in the exam room, or, even just reading the news, your brain is going to see the name of a city, say, the city of Los Angeles or Cook County, and immediately just scream, government defendant, immunity.
Oh, yeah, students do that all the time.
Right, but don't fall for it. Local governments, counties, cities, municipalities, school boards, they are not the state.
No, they're not. The 11th Amendment simply does not apply to them.
Which is so counterintuitive.
It is, but a private citizen can sue a city in federal court for damages all day long. The city might have other defenses, obviously, but sovereign immunity is not one of them.
Okay, I think of this using a sort of corporate analogy from the notes.
Let's hear it.
So the state is like the massive corporate headquarters.
Okay.
Right? They have the ultimate liability protection, the gold-plated legal shield. But cities and counties, they are like independent local franchisees.
I like that.
Yeah, they use the corporate branding. They operate under the corporate umbrella. But if someone slips and falls in their specific store, HQ isn't bailing them out. The franchisee has to fend for themselves.
That's a great way to look at it.
But, why is that the case? Why doesn't the shield just cover every single level of government, top to bottom? It seems like it should.
Well, the distinction really comes down to the underlying philosophy of federalism and inherent sovereignty.
Inherent sovereignty, okay.
Right. When the United States was formed, the states already existed as independent sovereign entities. They gave up some specific powers to form the federal government, but they retained their historical dignity and sovereignty.
Okay, so they were already there.
Exactly. But cities and counties, They do not have that history. They are just administrative subdivisions created by the state to handle local logistics.
Oh, I see.
Yeah, so because they lack that inherent pre-constitutional sovereignty, federal courts just do not extend that supreme level of protection to them.
Okay, that makes perfect sense. So we know who has the shield in its direct agencies, but not the local franchisees. The next logical question from our framework is question 3. For what relief
No. Right. What are you actually asking the court for?
does this shield block absolutely everything? Like if I sue the state, am I just entirely out of luck no matter what?
Not necessarily. The courts draw a massive bright line between retroactive relief and prospective relief.
Okay, so looking backward versus looking forward.
Exactly. Retroactive relief means you are looking backward. You are asking for money damages for past harms, like back pay for being wrongfully terminated or compensation for personal injury.
And what happens if you ask for that?
If that money is going to come out of the state treasury, the shield is up. That lawsuit is barred.
Okay, let me push back on this with a practical hypothetical, because if I'm the plaintiff, I'm definitely looking for a workaround.
Always.
So say a state agency unfairly fires me. It's completely unconstitutional, and they owe me $2 million in back pay.
A nice chunk of change.
Right. I know I can't sue the state of X, but what if I just pull up my legal complaint, literally cross out the state's name, write in the name of the director of the agency in their official capacity, and demand my $2 million from them? I mean, I'm suing a person, technically.
Yeah. The sources refer to that exact strategy as the caption trap.
A caption trap.
Yeah. You cannot bypass immunity simply by changing the name in the caption of the lawsuit. The court looks past the title on the paper and asks a functional question. Whose wallet is actually being opened here?
Oh, wow. Okay.
If you sue the agency director in their official capacity for back pay, that $2 million isn't coming out of the director's personal checking account.
Obviously not.
Right. It's going to be drawn directly from the state treasury. And because the state's bank account is on the line, the court just treats it as a suit against the state and the shield blocks it.
Man, so following the state's money just leads to a dead end.
Pretty much.
But wait, let's look at the flip side of that functional test. What if the state agency is just administering a massive pool of federal funds?
Okay. Interesting.
Say I'm suing for a payout, but the money wouldn't actually touch the state's own tax revenues. It would come straight from a segregated federal grant sitting in a separate account. What happens then?
Then the immunity completely evaporates.
Really? Just like that?
Just like that. Because the primary purpose of the 11th Amendment is to protect the state treasury from being raided by federal courts. If the state's own money is not at risk, the core justification for the shield disappears.
Okay, that makes sense. But this brings us to a massive, glaring problem.
Which is?
If we've established that you generally cannot get money for past wrongs, how on earth do you stop a state from doing something unconstitutional right now?
Yes. The ongoing harm issue?
Right. If a state official is actively violating my constitutional rights today and they plan to do it again tomorrow, I can't just let them keep doing it simply because I can't sue the state treasury.
And you're hitting on a tension that actually threatened to break the entire constitutional system.
Really?
Yeah. I mean, if federal courts couldn't stop states from violating federal law, then federal law wouldn't be supreme at all.
That's a good point.
This crisis gave birth to the ultimate loophole in constitutional law, and honestly the most heavily tested exception in the prep materials. It is a doctrine called ex parte Young.
Ex parte Young. It sounds like an exclusive VIP room.
It kind of is.
But it's actually your golden ticket across the moat. And to use it, lawyers employ what is basically a Jedi mind trick.
A Jedi mind trick. I like that.
Oh, yeah. You stand in front of the federal judge, you point at the state official who is violating your rights, and you say, "Judge, this isn't the state you're looking for. This is just a rogue officer."
And the crazy part is, courts rely entirely on that exact legal fiction.
They actually buy it.
They do. The rule of ex parte Young allows a private plaintiff to sue a state officer in their official capacity, provided they are asking for a prospective, meaning forward-looking injunctive relief to stop an ongoing violation of federal law.
Okay, but how does the fiction actually work?
The fiction works like this. The state itself is theoretically incapable of acting unconstitutionally.
Okay.
Therefore, if a state official is acting unconstitutionally, they must have been magically stripped of their official state authority the very moment they broke the federal law.
Yeah, we all know that's a lie, right? I mean, the official is driving a state car, cashing a state paycheck, and using state power to violate my rights, And the court just pretends they aren't the state.
They literally just pretend.
Why do we tolerate such an obvious fiction?
We tolerate it because it acts as the necessary pressure valve for American federalism. If you look at the actual history of the 1908 Ex parte Young case.
Yeah, the sources mention this.
Right. So the state of Minnesota passed a law severely capping railroad rates. And they attached massive ruinous fines and jail time for any railroad that violated it.
So the railroads were trapped.
Completely. The railroads couldn't afford to break the law just to test its constitutionality in state court. So they went to federal court and sued the Minnesota Attorney General, whose name was Edward Young.
Ah, Ex parte Young.
Exactly. They asked for an injunction to stop him from enforcing this allegedly unconstitutional law. And Young argued, "You can't sue me, I am the state."
Which functionally he was.
Right, but the Supreme Court realized that if they agreed with him, states could pass blatantly unconstitutional laws, threaten massive penalties, and federal courts would be completely powerless to review them.
That would just destroy the Constitution.
Exactly. So the legal fiction preserves the dignity of the state by saying the state itself isn't in trouble, while still allowing federal supremacy to actually function by stopping the individual officer.
Man, it's a brilliant workaround. So I can't ask for money for what you did yesterday, but I can get a federal judge to order you to stop violating the U.S. Constitution tomorrow.
Yes, exactly.
But our sources highlight a massive trap here. This Jedi mind trick completely fails if you are trying to make a state officer comply with state law.
Yes, it fails completely. Ex parte Young exists solely to vindicate supreme federal rights.
Okay.
Imagine a state official is violating their own state's environmental regulations. If you run to a federal judge and say, "Hey, use an injunction to make this official follow state law," the judge will throw the case out immediately.
Why? Because it's none of their business.
Basically, yeah. A federal court ordering a state official on how to interpret and execute their own state's laws is considered a massive, unacceptable invasion of state sovereignty.
Okay, that makes sense.
The loophole only opens if federal law or the U.S. Constitution is being violated.
Got it. And it also fails if the violation's completely in the past, right? Like, if the state violated my rights last year, but they've already stopped and there are no ongoing effects, I can't ask for a forward-looking injunction because there's just nothing left to enjoin. No ongoing violation, no ex parte Young.
Exactly. It has to be ongoing. So we have this mechanism for private citizens to stop ongoing harm. But what happens if the federal government itself, specifically Congress, decides they want to tear down the shield entirely?
Yeah, what if Congress wants to allow citizens to sue states for retroactive money damages? Can they do that?
This brings us to congressional abrogation.
Abrogation.
Yes. And the sources make it clear Congress does have the power to bring a battering ram to the fortress, but the Supreme Court has made it incredibly difficult to use. Congress has to clear two very strict hurdles.
Okay, what's the first one?
First, they need a clear statement of intent. They have to explicitly write into the statute, states can be sued under this law. They cannot just imply it.
Okay, so no reading between the lines.
Exactly. But a clear statement is just the beginning. The second, much harder hurdle is that Congress must be acting under a valid constitutional power to abrogate that immunity.
Wait. Congress regulates the entire national economy under Article 1, specifically the Commerce Clause, right?
Yes, they do.
So if they can tell a farmer exactly how much wheat to grow on his own private land, surely they can force a state to pay damages for violating a federal labor law.
Actually, they cannot. And this is a foundational exam-safe contrast.
Really?
Really, if Congress passes a law under the Commerce Clause and explicitly says states can be sued for damages for violating this law, that abrogation is unconstitutional.
Wow.
Yeah, Article 1 powers generally cannot be used to strip a state of sovereign immunity. The only major power Congress can routinely use to abrogate is Section 5 of the 14th Amendment, which gives Congress the power to enforce civil rights.
Why the difference, though? Why does the 14th Amendment work as a battering ram, but the Commerce Clause doesn't?
It is all about the historical timeline of the Constitution.
Okay, break that down for me.
So the Commerce Clause is in Article 1, written in 1787. The 11th Amendment, which created the shield of sovereign immunity, was ratified a few years later in 1795, and it was specifically designed to protect state treasuries from being sued under those original Article 1 powers.
Ah, so the shield was built to block the Commerce Clause.
Exactly. But the 14th Amendment came along in 1868 after the Civil War. Its entire historical purpose was to radically alter the balance of power and limit state sovereignty to protect individual rights.
So it trumps the shield because it came later.
Yes. Because the 14th Amendment came later and was specifically designed to restrict states, it is allowed to pierce the 11th Amendment shield. Article 1 cannot.
That is fascinating. But even with the 14th Amendment, Congress can't just write a blank check, right?
No, not at all.
Because the sources emphasize a specific test: congruence and proportionality. How does a court actually measure that?
The court looks for a documented historical pattern of states violating a specific constitutional right. If Congress wants to subject states to lawsuits for damages, the remedy they create must be congruent and proportional to that historical problem.
So they need receipts.
They need major receipts. Take patent law, for example.
Okay.
Congress once tried to pass a law allowing states to be sued for patent infringement, arguing that patents are property and the 14th Amendment protects property.
Makes logical sense.
But the Supreme Court struck it down. Why? Because there was no massive historical pattern of states rampantly stealing patents.
Yeah.
The legislative sledgehammer was just not proportional to the non-existent problem.
Oh, I see.
Now, compare that to racial discrimination or voting rights, where there is a deep, highly documented history of state violations. In those cases, abrogation under the 14th Amendment is highly appropriate.
Okay, so if Congress wants to force states to follow a new regulation,
Right.
and they can't use an Article 1 power like the Commerce Clause to make them liable for lawsuits, they are stuck.
Pretty much stuck.
Unless
Yeah.
they just bribe them. Let me throw a hypothetical from the notes regarding the spending power.
I love a good hypothetical.
Okay, so can the federal government say to a state, hey, we have $1 billion in highway funds. It's yours. But the string attached is that you must waive your sovereign immunity and allow private citizens to sue you.
Yes, that is a conditional waiver, and it is entirely constitutional.
Really? Just a straight-up bribe.
Under the spending power, Congress cannot directly order a state to surrender its shield, but they can offer a massive financial incentive. If the condition is clearly stated up front and the state knowingly accepts the funds, the state has voluntarily chosen to lower its own drawbridge.
Which brings us to our final set of questions. Consent and capacity. If a state can voluntarily lower its drawbridge for $1 billion, are there situations where a state just willingly waives its immunity without a massive federal bribe?
Oh, sure. A state can absolutely waive its immunity on its own, perhaps to allow citizens to sue over, breach of state contracts. But the courts are fiercely protective of state dignity. The waiver must be unmistakably clear. We are talking about an explicit state statute that literally says, the state of X consents to be sued in this specific court for this specific class of claims.
Okay, because I read this section in the notes on implied waiver, and honestly, the standard is staggering.
It's a very high bar.
Think about it. If I join a local intramural sports league, I implicitly agree to be bound by their rules.
Right.
If I break a rule, I face their grievance committee. My participation is my consent. Why doesn't a state agree to be sued just by willingly participating in a heavily regulated federal program?
Because states are not playing in an intramural league. They are sovereign entities.
Right, the dignity thing.
Exactly. Let's say a state voluntarily joins a massive federal environmental initiative. They accept regulations, they submit reports, they actively participate for decades.
Yep.
A citizen finds out the state violated one of those regulations and tries to sue, arguing, well, they participated in the program, so they implicitly waived immunity.
Makes sense to me.
The federal court will dismiss the case immediately. Mere participation in a federal program, no matter how complex it is, does not equal an automatic waiver of immunity to a lawsuit.
Wow.
Yeah, unless the state explicitly wrote a statute consenting to suit, or Congress explicitly attached a waiver condition to funding that the state accepted, the default setting is always that the shield remains up.
They really, really do not want these lawsuits happening.
No, they don't.
But there is one final workaround we haven't touched on, and it bypasses the state's fortress entirely.
Oh, this is a good one.
It goes all the way back to question 1 of our framework. Who is being sued? We already talked about how suing a state officer in their official capacity for money is just a sneaky way of trying to raid the state treasury, and that gets blocked.
The caption trap.
Right. But what if we sue the officer in their personal capacity?
That shifts the paradigm entirely. When you sue an official in their personal capacity, you aren't asking the state treasury to pay for their mistake. You are going after the officer's own personal bank account.
Wait, seriously?
Seriously. You want their house, their savings, their personal assets to compensate you for the constitutional violation they committed.
That is a terrifying prospect for a government employee.
It is, but because you are not touching the state's money, state sovereign immunity simply does not apply. The 11th Amendment does not protect an employee's personal wallet.
Okay, so they're completely defenseless.
Well, no, that officer will almost certainly invoke a different defense called qualified immunity.
Ah, qualified immunity. We hear about that a lot.
Right, which protects government officials from personal liability unless they violated a clearly established statutory or constitutional right. But that is a defense for the individual. The state's impenetrable shield of sovereign immunity won't save them.
Okay, we have navigated an incredibly muddy, trap-filled area of constitutional law today. Let's do a rapid-fire synthesis to make sure the mechanics of this are just locked into your brain.
Sounds good.
So we started at the fortress. The state and its direct agencies have the sovereign shield. Local cities, counties, and municipalities. They're out in the cold. No sovereign immunity for them.
None.
Then we followed the money. If you want retroactive money damages paid out of the state treasury, you are out of luck. The caption trap won't save you.
Right.
But if you want a forward-looking injunction to stop an ongoing violation of federal law, you can use the Jedi mind trick of ex parte Young and sue the specific state officer.
As long as it's ongoing.
Exactly. Now, if Congress wants to step in and shatter the state's shield, they need a crystal-clear statement in the law, and they must use a valid power, which functionally means the 14th Amendment, passed after the Civil War, not Article I powers like the Commerce Clause.
Because of the timeline.
Right. And their remedy must be congruent and proportional to a real historical problem.
Like the receipts we talked about.
Yes, the receipts. And finally, a state can waive its immunity, but it has to be incredibly explicit. There are no accidental or implied waivers just because a state joined a federal program. If you want to bypass the state entirely for damages, you have to go after the officer's personal bank account in their personal capacity.
Honestly, when you lay the rules out chronologically and mechanically like that, the fortress doesn't seem quite so impenetrable.
It really doesn't.
The system actually provides very specific, narrow pathways across the moat to ensure the Constitution is still the supreme law of the land. You just have to know exactly which historical stone to step on.
You definitely do. But I want to leave you with one final kind of mind-bending concept to ponder, building right off the structural rules we just dissected.
Oh boy.
So we know that the primary way a private citizen can stop a state from violating their constitutional rights in federal court is through the ex parte Young loophole.
Right, the forward-looking injunction.
And as we learned, ex parte Young strictly requires you to name a state officer as the defendant to enjoin them from enforcing the law.
Yes.
But what happens if a state legislature gets incredibly creative?
Okay.
What if they pass a blatantly unconstitutional law, but they completely privatize its enforcement?
Oh, wow.
Imagine the state law explicitly says no state official, no attorney general, no police officer is allowed to enforce this statute. Instead, we are giving the power to sue violators exclusively to everyday private citizens.
That is devious.
Right. If the state completely removes its own officers from the enforcement equation, there's literally no government official left for you to sue under ex parte Young.
Because there's no state officer enforcing it.
Exactly.
Okay.
Does the ultimate shield suddenly become completely impenetrable? Can a state build a legal fortress so clever, using the very rules of sovereign immunity, that even the federal courts can't find a single door to open?
That is a terrifying thought.
It's something to chew on next time you think the rules of the game are set in stone. Thanks for joining us on The Deep Dive.